Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a very common situation that lawyers see, which is, I got fired, I'm mad, I want to sue. We'll talk about whether or not that necessarily is a good idea or not in just a moment. So, anybody who has ever been fired knows that it's an unpleasant experience. Speaking as someone who has been fired twice in his life, I can tell you that it was absolutely no fun whatsoever. Um, Even though in both cases I got severance pay, I left feeling like I had received less than what I should have received, particularly in the area of respect. But be that as it may, I wanted to go over today a little bit of what it means with regard to being fired and having a right to sue about that. So let's talk about that. And first off, racism, sexism, ageism, disability, all of those are evil and wrong. People should have a right to work, and the color of their skin or anything that they cannot change should not be held against them. But unfortunately, every day in this country, by one estimate, 3.4 million times a year, people are discriminated on the basis of something they can't control. Their race, their national origin, the color of their skin, the religion that they belong to, all of these reasons are things that should not happen, but do happen, and sometimes with great regularity. Now, most states are at-will employment states. What does at-will mean? At-will means you can be fired for any reason or no reason, but not for an unlawful reason. The example that I often use when talking to clients is, you can be fired because you wore tennis shoes instead of loafers on a particular day, and that's completely rational, completely okay. You can be fired and they can give you absolutely no reason for why you're being let go. You're just being let go. Goodbye. And that's okay. But what you can't be fired for is an unlawful reason. Now, that usually comes down to two specific things. One is discrimination on the basis of age, sex, race, national origin, religion, or disability, or pregnancy. All of those are things that are, by federal law, things you can't discriminate on the basis of in employment. That doesn't mean it doesn't happen. It just means that it's unlawful. And the only remedy for that, usually, is to sue. The other reason you can sometimes pursue a claim for being fired is if you blow the whistle. Public policy in many states says somebody who reports something that is criminal or against public policy is protected from termination on that basis. But the contours of the whistleblowing protections are all over the place. There is a whistleblowing protection for federal people who complain to the government about false claims. The False Claims Act has a specific non-retaliation clause in the statute. It's almost never enforced because courts have interpreted it in ways that make it difficult to apply. You may think, wow, it sounds like he's telling me I really shouldn't pursue a claim against somebody. And I'm not really telling you that. I want you to go into it with your eyes open. So let's talk a little bit about where these claims go south. And where they go south is evidence. And by evidence, what I mean is there is always a huge gulf between what we know and what we can prove. For example, you go into the kitchen, you take the top off the cookie jar, and shazam, there's no cookies there. Now, you know that little 7-year-old that's hiding back in his bedroom ate those cookies. You know that. But you can't prove it. Unless you have evidence. Now, if you have evidence, cookie crumb trail that leads back to his bedroom, okay, that's some evidence. When you go in and knock on the door and say, "Are you eating something?" and he says, "What? Well, then there you go. You've got some evidence. It's the same in discrimination. You have to have some evidence of discrimination. And usually that comes in the form of witness statements about things that were said or things that witnesses heard a manager or employer say. For example, somebody who says, I don't like Hispanics, I don't like black people, and says that where it can be heard, that is some evidence, assuming that it can be tied back to the speaker, and that speaker has some kind of role in the employment process. That indeed can be an evidence of racial or national origin bias. And as a result of that, you may be able to get to a jury on something like that. But just the fact that you are the only person of Hispanic origin in the company and you were the only person fired, that is usually not enough. You need to have some evidence. A lot of times employers are stupid and they write emails to one another saying, we got to get rid of these, fill in the blank, women, pregnant women, people who are over 40. I was involved in a case involving teachers, and the assistant principals that were at the heart of that case essentially said, we're going to have to get rid of the old dead wood. And they made that statement to numerous people. And it came back to bite the district in that case. So you can get evidence of this kind of discrimination, but you have to have it in order to move on to the next stage. And that's because the first thing that happens when you file a discrimination lawsuit, before you even file the discrimination lawsuit, you have to go through the Equal Employment Opportunity Commission or its state deferral agency. In Missouri, for example, that's the Missouri Commission on Human Rights. And assuming that they do an investigation and find that there is some evidence of discrimination, sometimes they will take your case and litigate it. Other times they will try to work out some kind of conciliation with the employer. Now, usually this doesn't mean people get their jobs back. Usually it means there's some kind of de minimis payment and you have to sign a confidentiality statement. And a lot of people don't want to do that. But there is at least some evidence that these deferral agencies do some good work in egregious cases. If the government does not wish to pursue your discrimination claim, they will issue what's called a right to sue letter. And a right to sue says you've exhausted your administrative remedies through the Equal Employment or through the Civil Rights Act, and now you have a right to go to court. But when you get to court, the first thing your complaint will be met with is a motion to dismiss. And basically the motion to dismiss will say you can't prove that you were discriminated against. And if your pleading isn't drafted with a lot of facts that show this racial or national origin or pregnancy bias, then there is a good chance it will be dismissed at that stage. If it does show that, then you will enter into discovery. There will be depositions taken. And of course, all of the people who have fired you will swear that you were the worst employee that they've ever hired. You were lazy. You were stupid. You couldn't follow directions. You were never on time. All of these are what I would call pretextual reasons for getting rid of an employee. And unfortunately, sometimes they're real reasons, but oftentimes in discrimination contexts, they are simply pretextual. And if they make this showing, then you will have an opportunity to make a showing that it is indeed pretext. For example, if they only tend to fire black people for being tardy, that may be a strong indication that they are biased against that particular race. If we take a look at statistics, and I'll link this article below, but there's an article out there on the internet that reviews a book written by some professors, and basically they found that there were 3.4 million cases of racial discrimination in the U.S. every year. I don't know how they did that. It's an estimate. It's not a hard number. But that's their estimate. Of those 3.4 million cases, 31,000 of those are reported to the EEOC or their deferral agencies. Of those 31,000, about 15% get some kind of conciliation treatment through the EEOC or the state deferral agency. And again, this usually means that somebody doesn't get their job back. And as a result, they have to sign some kind of paper in order to get paid a little bit of money to go away. I don't know why people consider that to be a favorable outcome. I think it's sort of a travesty, but that is sort of the model that some of these offices use. Of the claims that remain after those that are looked at by the deferral agency, about 5,000 right to sue letters are issued every year. Of the 5,000 right to sue letters that are issued, those cases are filed in federal court. About 60% get some kind of settlement. Now, the average settlement appears to be around $30,000, but in order to get that settlement, you're going to have to sign a confidentiality statement, and you're going to have to agree not to get your job back. And you're probably going to wind up paying your own lawyer fees out of that money. That's what happens when you reach a settlement. If you are successful and you litigate it through to the end, you can make them pay your lawyer's fees. But that is a long, hard road. The reason I say that, of the claims that get a right to sue letter and get past those two initial stages, only about 6% wind up going to the point where they can be adjudicated by the court. And many are adjudicated on summary judgment unfavorably to the plaintiff. Of the 1% that go to trial, only about 1/3 of that 1%, I think the statistic that they used in the article was 0.13%, only that many get some kind of favorable outcome at trial. And of course, that's not the end of the matter because there are always appeals. So where am I going with this? Well, one of the things that I found is that nothing happens for no reason whatsoever. And you've often heard people say, I'm sure, that God doesn't close a door, that he doesn't open a window. For me, the window has been pretty big in both instances. I was able to find a different job, a better job, and live a better life without ever thinking about the places where I worked where they let me go. And the reason I don't have to think about them is because I have made my life better by making better choices about the employer that I have. And I have a great employer. So one of the things that I would point out to you is, even though it is difficult sometimes to forgive people, it is better to forgive and forget and move on and live your best life than it is to go through this freight train of a litigation against an employer. It takes a lot of time. You have to have a lawyer who's done this a lot in order to get a good result. And even then, you can wind up with a judge who just doesn't like these claims and rules against you. You may have to go to the appellate court 2 or more times before you actually get a favorable result. So that's my take on employment law and employment discrimination. If you do have a claim, the National Association of Employment Lawyers is a good place to start, good place to find somebody in your area who does this kind of law. You definitely want somebody who does it and does a lot of it, not somebody who says, most of the time I draft wills, but I bet I can handle this. Not the right lawyer for you. I wouldn't be the right lawyer for you, frankly. Even though I know a lot about this area based on appeals I've handled, I would not be the right lawyer for you on this kind of thing. So hopefully that clears some things up about these kinds of cases. If you have any questions, please leave them in the comments down below. Thank you very much for watching. And a note to people who employ other people. It is always better to treat people honorably. If somebody isn't doing a job, help them do it better. And if they decide to leave, that's their issue. But you should never force somebody out because you don't like the color of the skin or the hijab that they wear. That's just wrong. Have a great day. We'll catch you on here next time.